Stay out of Illinois for now. Part 2. Welcome to Law and Society. I'm doing this because Illinois is my state and I love it so much. I love my state. I love Illinois. I love Chicago. But I'm actually doing this because I missed the second lawsuit that the state of Illinois had levied against the federal government, and that also did not see the order that Judge Perry had issued. And I was talking about the private plaintiff's case against federal agents in the previous episode that I aired today. So now what I'm going to do is tell you what happened. State of Illinois sued the federal government in the Northern District of Illinois in the Eastern Division in Judge April P. Perry's court for restraining order to stop the deployment of National Guard to the United States, within Illinois. So the order has temporarily enjoined from ordering the federalization and deployment of the National Guard of the United States within Illinois. Because of Professor Heather Cox Richardson's Letters to an American, which I think is necessary reading for everybody, this was brought to my attention that there's another case that talks about the National Guard, and that was brought by the governor of Illinois and the city of Chicago. And in that, from the bench, the judge said the following, and I'm reading this from Letters from an American. Federal judges are standing firm against the administration's overreach. Today, U.S. District Judge April M. Perry stopped the federal deployment of 200 National Guard troops from Texas and another 300 from Illinois in and around Chicago, Illinois, for 2 weeks. I have found no credible evidence that there is a danger of rebellion in the state of Illinois, Perry said. She pointed to the refusals by grand juries to indict protesters accused of assaulting law enforcement and said they cast doubt on the Department of Homeland Security's credibility and assessment of what is happening on the streets of Chicago. And then in the written order, she ordered the enjoyment for 14 days of the federalization and deployment of the National Guard of the United States within Illinois. And that obviously includes all of the other National Guards from other states that Donald Trump is talking about bringing to Illinois. He's already brought Texas. He's now talking about bringing in California Guard. Now, I'm not going to go over the full complaint simply because it is like 69 pages, but I want to read you pertinent parts of it where the state of Illinois pleads that the deployment of the federalized National Guard, including from another state, infringes on Illinois' sovereignty and right of self-governance. It will cause only more unrest, including harming social fabric and community relations and increasing the mistrust of police. It also creates economic harm, depressing business activities and tourism that not only hurt Illinoisans, but also hurt Illinois' tax revenue. Illinois asks this court to declare these actions unlawful and enjoin them immediately, and asks permanently, but that doesn't happen. It's just ask for a temporary restraining order. Illinois says once the National Guard members have been federalized, they are for all relevant purposes legally equivalent to members of federal armed services. One crucial distinction between the National Guard deployed under Title 32 and those deployed under Title 10 is that only members deployed under Title 10 are federalized and functionally equivalent to federal forces. Now, mind you, that is the law that Donald Trump's regime has picked to activate and federalize the National Guard. Then Illinois says that what they are doing is also a violation of the Posse Comitatus Act, which prohibits the use of military to enforce civilian laws. And it goes more into it. It says that 10 USC 12406 does not contain any express authorization from Congress for National Guard to engage in domestic law enforcement, including civil immigration enforcement. And that is because, according to the Posse Comitatus Act, you cannot perform law enforcement duties unless they're expressly provided by Congress. And Illinois here says that there's been no such delegation of power that allows the federal government to federalize the National Guard for the purposes of law enforcement activities. Department of Defense instructions cover broad swath of law enforcement tasks and make clear that the directive of October 4th cannot lawfully be carried out by federalized National Guard troops. Similarly, the Immigration and Nationalization Act does not have any provision for any member of the military or the National Guard to participate in its activities. Then there are pages and pages of the factual allegations made about what and the process in which Donald Trump has created this animus and this sort of negative narrative around what is happening in Chicago and in other states that have different political affiliations than the current regime, Donald's regime, the MAGA regime. So Illinois says prior to the federalization order and Texas mobilization order regarding deployment in Illinois, defendants federalized National Guard troops in California, Washington, D.C., and Oregon over the objection of their leaders. No circumstances in any of these jurisdictions warranted the federalization and has been subject to Trump's taunts about crime. Each of them, including Chicago and Illinois, is being targeted for this harmful and coercive conduct by defendants. So there's a national propaganda campaign that is ongoing, and this particular plea by the state of Illinois and the city of Chicago is that there is no factual or legal predicate exists for deploying the military in Illinois. There's no insurrection, there's no rebellion. The federal government is able to enforce federal law in Illinois. The manufactured nature of this crisis is clear. Trump first announces plans to send National Guard troops from the Oval Office on August 22nd. His rationale then, as at many points, was his view of Chicago and Illinois as crime-ridden. At that event, he asserted that his National Guard deployment in Washington, D.C. had reduced crime and he wanted to send troops in Chicago for this same reason. There's been, in front of Marine One, Donald Trump spoke about crime in Chicago and said the city needs help. He then claimed that he had solved the crime in D.C., where he previously had sent troops, and said we're going to do that in Chicago. If you have military on the streets 24 hours a day, you're not going to see crime. But that is not the long-term way to solve crime, because the minute the military goes away, the crime comes back with a vengeance, and it actually leaves local law enforcement unable to handle what befalls them, because it breaks through and it already breaks the trust that local law enforcement builds with the community, and it also undermines community policing efforts that cities like Chicago employ in order to bridge the gaps between citizens and the government. So the federalized National Guard harms Illinois. So this is the crux, the major state argument here is Illinois sovereignty is harmed by this illegal, unlawful intrusion, by the infringement of its sovereign interest in managing law enforcement within its borders, including the authority to manage protests and unrest. The police powers reserved to the state of Illinois include the authority to regulate its internal law enforcement activities. Likewise, those powers include the work of policing its own populace. Defendants' effort supersedes Illinois' authority to regulate and oversee its own local and state law enforcement. It reflects an unconstitutional attempt to infringe on Illinois' power. The federalization order and the implementing agency's actions also injure Illinois' ability to give full effect to its own laws protecting residents' health, safety, and rights, harming its sovereign interests and intruding on an area traditionally left to states. Defendants' use of the National Guard troops to control protests or guard property amounts to an usurpation of the role of domestic law enforcement. Defendants' conduct will also directly and concretely interfere with current and planned law enforcement activities of state and local authorities. The unlawful deployment of federalized National Guard troops to usurp the law enforcement role will directly interfere with the ability of the state and local law enforcement to deal with any given situation. Further, military troops are not law enforcement. Recent developments of troops elsewhere in the country have provoked protests and escalated tensions. The diversion of the National Guard personnel renders them unable to engage in other critical work and harms the state of Illinois. The federal deployment harms plaintiffs' ability to provide important services to the community. It harms Illinois and the city of Chicago's business activities. It violates 10 U.S.C. 12406 because the president goes beyond the authority of that statute. It goes beyond the authority of the Posse Comitatus Act, and it is Donald Trump's actions, this regime's actions, are contrary to the 10th Amendment of the Constitution, and it is in violation of the equal sovereignty under the Constitution, as well as violation of the Administrative Procedures Act of arbitrary and capricious actions against one party, and violation of Administrative Procedures Act that is action in excess of statutory and regulatory authority. And so it's just a list of violations, and the violation of U.S. Constitution separation of powers and the violation of the U.S. Constitution militia clauses that gives the power to Congress, except in extreme circumstances where they delegate it to the president. It's also a violation of the U.S. Constitution's Take Care Clause, claiming that the state of Illinois is claiming that defendants have violated the Take Care Clause by asserting authority over Illinois state militia that the Constitution and federal law expressly assigns to Illinois. Additionally, defendants have violated the Take Care Clause doctrine by and disregarding the limits of the Posse Comitatus Act, barring the participation of federal military enforcement forces in law enforcement, and therefore asks for this injunctive relief. And the court grants the relief. Mind you, this is, again, a temporary restraining order. It lasts for 14 days. We're going to see what happens. I think that a notice of appeal has already been filed. If not, expect one to be filed going to the 7th Circuit Court of Appeals. And we'll see if they stay this order or not. The 9th Circuit Court of Appeals stayed the order of the Oregon judge, Judge Immergut, to federalize the troops, but did not stop the order that said that you may not bring National Guard troops into Portland, into that district. So we're going to see how the 7th Circuit deals with this ruling from Judge Perry, and then there's also the previous ruling by, I think, was it Judge Mills? So, sorry about the confusion. This is the case that is by the state. The previous one was about the plaintiffs. That's why I was a little confused why the state wasn't one of the plaintiffs in the first case. But, at this time, we are being flooded with information, and I kind of missed this one. And I'm glad I talked about the previous one first, because that one is novel in its approach in claiming the First and Fourth Amendment violations of the federal government by the use of their federal agents. With that said, thank you so much for listening. Please like, share, and subscribe. Remember to share and pass on the message. And I will talk to you soon.